Handbooks contain policies which can be changed, and employees should be informed what those changes are, but it is not a contractual entitlement, and therefore that employee doesn't need to agree to the changes.
This is Complex Made Easy with Dezan Shira Associates, in partnership with Laytons ETL.
The difference between, of course, a contract of employment and a handbook and policies is that contracts of employment are contractual entitlements, and therefore to change them one has to give notice of at least 30 days, and that has to be reasonable, and any changes have to be agreed by the employee. Handbooks contain policies which can be changed without the employee's consent. For example, they will contain provisions relating to insurance, or how holidays to be booked, or other non-contractual requirements as to how to implement what is perhaps a contractual entitlement. Those policies can be changed. The employee doesn't have to be notified, although it is a good idea to do so they know how to actually do what it is that the employer requires of them. One of the great difficulties that is often encountered is that employers and their human resources teams will sometimes mix up the contractual requirements set out in a contract of employment and those in the handbook. It is quite frequently the case that one will see a contract of employment with additional contractual clauses being put into specifically a handbook. In our view, that is actually quite poor practice and causes all sorts of confusion, and in particular restrictive covenants sometimes are put in handbooks, and handbooks are often not signed for, and therefore these restrictive covenants may in fact not be valid. So detailed and careful advice is required and needed when looking at these this sort of documentation.
Plainly speaking, a staff handbook is a comprehensive document that stipulates all internal rules regarding the company, which all employees need to comply with. A good staff handbook covers not only the rules and obligations the employees should observe, for example, attendance, the administration formalities, the code of conduct and disciplines, but also the rights and entitlements the employees may enjoy, for example, the rest days, annual leave arrangements, promotions, and incentives. A staff handbook, strictly speaking, is not part of the employment contract, but a proper staff handbook is something an employee must comply with as necessary to perform the employment contract. So you can regard a staff handbook as an extension of the employment contract, provided that the staff handbook is lawfully formulated and lawfully effective and binding. When you, as the employer in China, formulate or revises the staff handbook on matters which directly involves employees' important interests, such as remuneration, working hours, rest periods and off days, labor safety and health, insurance and welfare, staff training, labor discipline, and so on. Such formulation or revision must be discussed with all employees or trade union, who will have the right to provide their opinions or propose amendments. You, as the employer, shall negotiate with the trade union or employees fairly before making a decision. After finalizing the staff handbook, you should notify all employees. We call these formalities democratic process. Only after going through this democratic process will the formulation or revision of a staff handbook become effective. If you are interested to learn more about Dezan Shira, you can visit us at dezshira.com. And if you are interested to learn more about Laytons, you can visit them at laytons.com.
If you want to learn more about employment contracts in China and the UK, reach us at uk.ireland@dezshira.com. The UK and Ireland desk at Dezan Shira Associates assists British businesses with market entry, legal, finance and HR in Asia. To stay up to date with the latest investment news into Asia, visit and subscribe to asiabriefing.com.